This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about the concept of fortuity and why it is required that a claim against an insured must be fortuitous and not intentional, and why the tort of tortious interference requires an intent to cause harm and therefore is an excluded peril. Defamation, however, is a covered personal injury because it does not require an intent to cause harm. In a case brought by Robert Hole, M.D., he appealed from a March 3, 2023 order granting plaintiff State Farm Fire and Casualty Company's motion for summary judgment, denying Dr. Hole coverage under the policy issued by State Farm. In the case entitled State Farm versus Dr. Robert Hole, M.D. et al., the Superior Court of New Jersey Appellate Division on March 21, 2025, ruled that a lawsuit filed against Dr. Hole by Michael Russonella, D.O., that alleged Dr. Hole made false statements regarding Dr. Russonella's alleged misconduct at St. Mary's Hospital in Passaic, New Jersey, was available to receive defense and indemnity from State Farm. Dr. Hole sought coverage from State Farm to defend the action, and the central question was whether State Farm was required to defend the action and indemnify Dr. Hole once the tortious interference count was the only remaining claim. Initially, Dr. Russonella sued Dr. Hole only alleging defamation. State Farm defended Dr. Hole under a reservation of rights. Because of the potential for an excess verdict and punitive damages alleged, State Farm's letter also advised Dr. Hole of his right to obtain personal counsel, and that State Farm's defense of the action by the attorney on your behalf is not to be considered a waiver of such policy defense or of any policy defenses which may be involved in the suit. In September of 2017, the trial court dismissed Dr. Russonella's defamation complaint as untimely under the statute of limitations. Dr. Russonella subsequently filed an amended complaint alleging tortious interference with business. State Farm sued, seeking declaratory relief, claiming it had no duty to defend or indemnify Dr. Hole regarding the claims asserted by Dr. Russonella. It asserted Dr. Russonella alleged Dr. Hole intentionally interfered with his business relationships, and further asserted that in making untrue and malicious statements, Dr. Hole targeted to injure Dr. Russonella, and that Dr. Hole knew the statements were untrue, and the policy exclusion for personal and advertising injury arising out of oral or written publication of material with knowledge of its falsity precludes coverage. When the facts present a single unavoidable resolution and the evidence is so one-sided that one party must prevail as a matter of law, then a trial court should grant summary judgment, and Dr. Hole argued a tortious interference claim does not require an intention to cause the injury alleged. Rather, he asserts, the intent required is tortious interference claims is an intent to interfere. The interpretation the court found of an insurance policy, like any contract, is a question of law. Coverage provisions are to be read broadly, exclusions are to be read narrowly, and potential ambiguities must be resolved in favor of the insured, and the policy is to be read in a manner that fulfills the insured's reasonable expectations. By contrast, if the plain language of the policy is unambiguous, the court will not engage in a strained construction to support the imposition of liability or write a better policy for the insured than the one purchased. A complaint based on tortious interference must allege facts claiming that the interference was done intentionally and with malice. Malice is defined to mean that the harm was inflicted intentionally and without justification or excuse. A tortious interference cause of action is excluded claim because not only does the tort require intentional interference, it also requires malice or an intent that the harm was inflicted intentionally. That is, the tortious interference claim intrinsically includes an intent to cause harm. The Appellate Division concluded, therefore, that the trial court did not err in finding that Dr. Hull was not entitled to coverage under the State Farm policy, and even though State Farm initially provided a defense for the defamation claim, it was not required to also defend Dr. Hull because the amended complaint for tortious interference alleged similar facts, but supported intentional conduct. In my opinion, liability insurance provides defense and/or indemnity only for fortuitous conduct. Intentional acts are excluded by every liability insurance policy, since providing such coverage would encourage wrongful or illegal conduct. The court concluded properly that although the defamation claim was a fortuitous loss, the tortious interference claim required intentional conduct was not fortuitous, and State Farm was entitled to a judgment. It owed no defense or indemnity to Dr. Hull after it successfully protected him from the defamation claim. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL selma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 5,000 blog postings. Please tell your friends and colleagues about the blog and these videos. They're free, so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.